Good morning. Good morning. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County. This is the civil motions and hearing calendar for January 15th of 2025. This is the 10 a.m. calendar. I'm going to call the calendar and then we'll proceed from there. There's an individual who has iPhone as their name. I need you to put your first and last name or to let me know if you're unable to do that. All right. All right. The person whose name is iPhone, please unmute so you can tell me what your name is or rename yourself on the screen. All right, first case on the calendar is David Lewis Jr. versus Jasmine Crome versus State Farm Mutual.
Good morning, Your Honor. This is Jenna Huff. I'm here on behalf of Justice Wiseman for the plaintiff, David Lewis.
Hello, Your Honor. This is Ellen Liu on behalf of defendant Jasmine Crome.
Good morning, Your Honor. Tawana Hobson on behalf of State Farm.
Okay. All right. All right, so this is settlement issues.
Judge, essentially, we're requesting that the court order mediation for the UM portion of this case. The defendant has already settled.
All right. Any objection to the court order mediation?
I think that we should be able to resolve it short of mediation. We just got a new demand this morning. I mean, a new offer this morning, or demand. No, we got it. Sorry. We got a new demand this morning.
Okay, so when did the main portion of the case settle?
I'm not really sure how. July 11th of 2023, the defense settled their portion of the claim. It looks like from my notes, Mr. Spiesman and his staff have been reaching out to the UM adjuster since, or I'm sorry, the UM counsel since August of 23, and have not received a response as to go into mediation or settling the case. They did just have some communication this past week. I believe that the plaintiff's position is we would still like to get a mediation ordered so we can move forward in the event that communication isn't regular to be able to resolve the case.
All right. And any objection to this, Ms. Hobson?
I mean, we'll go along with whatever the court orders. I don't think it is necessary. There were issues with regard to coverage. So that was the holdup on discussions going forward. That issue has now been resolved, hence why we're able to move forward.
Ellen Liu for defendant Crome. I just request that the defendant be excused from the order of mediation insofar as we've already settled, so our presence would not be necessary.
Any objections to that?
No objection to that, Your Honor.
All right, so UM carrier and plaintiff will either settle the case or go to mediation within the next 60 days.
Yes, Your Honor, thank you.
All right.
Thank you, Your Honor.
Settlement needs to take place such that if y'all don't settle within that, let's do it this way, settle within 30 days, mediate within 60.
Yes, Your Honor.
All right, Ms. Powell, can we get a short order for that? So the defendant will be excused from mediation. Plaintiff and UM carrier will settle within 30 days. If they do not reach a settlement within 30 days, then they will mediate within 60 days.
Got it, Judge. Thank you.
All right, we'll get that out to you. Thank you. Y'all are excused.
Thank you,
All
Your
right.
Honor.
All right, Sally Anderson versus John Doe, Justme, and Rupert Law, Ashwood Ridge Holdings.
This case has been rescheduled, Judge.
One Main Financial Group versus Turquoise C.
Chris Scar on behalf of the defendant in that matter.
Is Miss or Mr. C present?
I represent the defendant, Turquoise Sai.
Yeah, I was asking if they were present.
Oh, well, no, they are not. They are not present.
And you're waiving their presence?
Yes.
Okay. Is there anyone here from One Main Financial? Last call for case 2022 CV 01261, One Main Financial.
Judge, will you give me a second just to double check that I didn't receive any type of notice?
Okay. All right, so it's my understanding that this is a motion for summary judgment filed by plaintiff. The defense's response was there was a lot of time between the time the motion was filed and the time the defense's response appeared. But my understanding is the defense's response was a issue with the real party in interest for the plaintiff. Is that an assignment issue? What's the issue?
Well, there are actually kind of three issues. I think we had a stipulated extension of time and finally responded, but there's a fundamental issue that no summons was ever issued by the court in this case. There's also, if the court should get past that issue and look at the merits, the named plaintiff is not suing as owner of the debt. They claim only to be a servicer. And when you look at the documents they filed, the note has been endorsed to a non-party to the case. So that is, it's a slightly different issue than we comes up with debt buyers that we see, but we have their allonge endorsing the debt to a non-party. But I think the court needs to take up our cross motion for summary judgment and motion to dismiss based on the failure to issue a summons in this case.
All right, and there was nothing from the plaintiff because it's their summary judgment motion. They would have asked for the hearing. So
No, there was nothing from the plaintiff.
All right. So, all right, your cross motion and go ahead. Let me hear it. So essentially, you've already given it to me.
Pretty much. I think we argued it in our brief, and I've given you the highlight. And once again, this was an unusual situation in which no summons was ever issued by the court. They actually used they kind of adopted a magistrate court form. The weird thing is the summons is like the magistrate court form that the clerk didn't know to sign. So what was served on my client was an unsigned notice of summons not issued by the court, but that basically tells her to answer to the magistrate.
let me be clear, Mr. Scar, this court has never issued a summons, but they always come from the clerk's office, or they are drafted by the attorneys who are doing the work. So I've been on this bench like 7 years. I've never issued a summons. So when you say it's not issued by the court, please be specific.
Yeah. Forgive me if I was unclear. When I say it was not issued by the court, not issued by you, of course, but usually the clerk would sign the summons and issue it. In this case, there was not the typical summons, which you're right, is prepared by the parties and they give it to the clerk and please issue this. Once again, I'm sorry if I was unclear, not saying you did or typically do this, but what happens is they did not prepare the court's typical summons. They attempted to adopt a form that's used in magistrate's court that actually says file your answer with the magistrate, and it was because the clerk's office is not used to this being something at the bottom of a statement of claim form, they never issued it. They never signed it. They never put the power of the clerk's office through the signature of the clerk on the summons. Okay,
let me ask you this. There was personal service on the defendant. Did the defendant not have notice? The whole point of the summons is to give notice. So are you claiming that the defendant did not have notice such that they could defend against this claim?
Well, obviously, Your Honor, the defendant.
But the lack of a summons and a defect in the summons is two different things.
Well, we're not raising an issue as to service. We're raising an issue as to process. And what happened here is there was no summons issued by the court, pursuant to the authority that we raised.
I'm not, to what purpose, Mr. Scar? I'm not sure. Do you have case law that says that if there's a defect in the summons, then it nullifies something to do with the case? Because the whole purpose of the summons and complaint is notice. And if you receive notice such that your defendant gave a timely response to the complaint, then it's a nullity.
Well, I'm sorry, I'm not sure. What is the nullity?
Okay, the whole point of a summons with the complaint is to give notice, correct?
Correct.
So what you're saying is they used a form from the magistrate court and it was defective as opposed to missing completely. Your defendant got notice and they responded. As I'm looking at the timeline, it seems like they filed a response to the claims. So what is the purpose of me? Like, what do you want me to do because they didn't do the right thing with the summons? Do I dismiss their whole case? What's the next step that you wish the court to take?
We would ask that the court dismiss the case for insufficiency of process. The case that we cited in our brief, Morris Bancroft paper versus Coleman, and I'll read it with the court's permission. I'll read. Oh, excuse me. I apologize, Your Honor. I forgive me. I'm kind of looking at two screens here, and I'm looking at the wrong one. But the case is Hall v. Young L.G. Harris College. Process is a mandatory precept issuing from a court. The mandate is set forth in the body of the instrument, which we call a process. And this may be printed or written out by any scrivener, like you were saying, that typically is prepared by the court and they bring it to the clerk's office. But it is the signature of the proper officer that gives it efficacy. Italics, in the court. From the instrument itself, the person to whom it is addressed or whom it is to be affected by it learns what is required of him, and from the official signature, he learns that it emanates from a court authorized so to command him. The mandate without the authenticating signature is no more process than would be the signature without the preceding mandate. Now, here's the thing. This, we, under 911-12B, we allow a defense of insufficiency of process. And this, under the case law of our state, this is insufficient process. Now, granted, Your Honor, this is a situation where we were able to say, yes, the court will be expecting an answer. And we filed an answer and we raised insufficiency of process as a defense. That is a defense established by 911-12B. I don't remember which of the subheadings within that, but this was the fundamentals of the power of the clerk's office, the power of the court, executing this. And now on top of that, there are, we figured out the right place to file an answer and we filed a timely answer, but we preserved this defense. And this is a situation where we would like the matter to be dismissed for want of for insufficiency of process. Now, we should be entitled to summary judgment on our cross motion as well, because the party that filed suit is not the party with the right to enforce this. But we think we ask that the court reach the motion to dismiss first and dismiss the case.
All right, so let's talk about the summary judgment on as to the proper party interest. So you're saying that because it was filed on behalf of a servicer and not the owner, is there a lack of an assignment, or what is the issue with that?
Well, what happens is the affidavit, the first page of the affidavit they filed in support of their motion for summary judgment. The second paragraph, there are two checkbox options. One box, which is not checked, says that One Main Financial Group LLC is the owner of the delinquent debt. That box is not checked. They are telling you in their own affidavit, we don't own this debt. The box that is checked says that they're a servicer. They also include an allonge, and in the allonge, it shows that the plaintiff has endorsed this over to a non-party. So, this is like, I don't get to endorse a check over to another party, and then I still get to enforce the check. I can't endorse it, and then I still get to cash it. So this is, and I believe we've cited the authority from the UCC that clearly says they have transferred the right to enforce this to a different party.
The One Main transferred it to?
One Main transferred it to Wilmington Trust as issuer loan trustee for blah, 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 trust 2021-1. So, and it's not even clear because this might be a Delaware, statutory trust. They have not stepped back. They have not responded to my cross motion at all. They have not responded to my motion to dismiss, and they have not shown up today to say their side of the story.
Okay.
But they are not the owner of the debt. They are not the real party in interest. There could be an issue in the future if there's a dispute where somebody else, where Wilmington Trust steps up and said, no, we're the right party to sue, and they'd like to sue my client again in the future. We have seen that and stranger things happen, but the company One Main, and this is an issue, we've not taken this issue up on appeal. We have one on this issue in other trial courts in Georgia, that One Main, when they show up to court as a servicer and literally, the unchecked box is they say they're the owner. When they show up as servicer and not as owner, we've had other trial judges rule that they're not the real party in interest. So, if the court gets past the motion to dismiss, does not grant the motion to dismiss, we ask that the court grant our motion for summary judgment that they are not entitled to move forward. Now, I think we have a third issue we've pled that there's some qualifying language in the affidavit where they say this is based on information and belief, which brings it under the standard on which you could grant summary judgment. But that's kind of our third argument. But, just the quick summary is we ask you in the first instance to dismiss the case because there was never process issued signed by the clerk's office. And the case authority we gave you and argued in the brief and that we've recited here today says that that's mandatory and that they're not within the power of the court because that happened. Now, notwithstanding the fact that we were able to connect the dots and file a timely answer, but that's still something that we have asserted, preserved, and we ask the court to rule on in the first instance. If you get past that, then One Main has told you they are not the owner of the debt, and they have endorsed this away, and they are not entitled to collect because they are not the real party in interest.
All right. You make some good arguments, Mr. Scar. And I will go ahead and issue an order based on the fact that One Main seems to have abandoned their summary judgment motion by not appearing today, and B, you have 3 arguments that the court is going to consider on your cross.
Thank you, Your Honor.
All right, thank you, sir.
All right.
All right, next is Erica Gibson versus Uganda Levy versus State Farm. Gibson. All right, Ms. Powell, did you hear anything from these individuals? Ms. Gutter Parker?
Yes, Judge, this case was rescheduled.
Okay.
And the next case, 2023 CV 00081 was also rescheduled.
Okay. All right, Velocity Investments versus Samuel Hall. Velocity Investments, Samuel Hall. Okay, so I'm here for Velocity Investments versus Samuel Hall. It is a request for an order on our motion in limine and business record affidavit in support of our motion for default judgment. All right, so the lady in the courtroom, I guess, is here for Velocity Investment. Deputy Whitson, what happened to the attorney who was in the courtroom? Oh, hey, different deputy.
Hello, she stepped to the other courtroom, 303.
Okay, so when she comes back in, let me know and we'll get back to her case, okay?
Yes, ma'am.
All right, thank you.
Oh, she's here, ma'am. She's here, ma'am.
Oh, she's here.
Hello, Your Honor.
Hi.
Hi. I'm so sorry for the inconvenience. I've been
That's
running
okay.
back and forth all morning. But my client's work, my firm submitted documents in October of last year, a motion committee and the business record affidavits that were requested to support our motion for default judgment.
All right, so I have sounded, I'm sorry, I have a Victor Newmark, but I don't think you're Victor Newmark.
I am Allison Richards.
Allison Richards. All right, so Ms. Richards, I've sounded for parties in this case. You had sent me a notice and the deputy confirmed that you stepped out to go to the other courtroom. So your parties are present. Mr. Hall has not shown up. You have presented all of the information necessary for default. The court, the plaintiff wished to rest on its affidavit in support of its unliquidated damages. Is that correct?
That's correct, Your Honor.
All right, so we will issue an order. And in fact, if you've included a proposed order, we'll sign that one. All right, thank you.
All right, that concludes my business before the court. May I be excused?
Yes, ma'am, thank you.
Thank you.
All right, next is Eddie Dukes versus Road Dog Trucking.
Your Honor, Luke Kennedy for the defendants in that case, and I don't see anybody from plaintiff here.
Daniel Johnson for Mr. Dukes.
Okay,
And ma'am,
so,
I'm the court reporter, Jennifer Cormican. I was requested by Mr. Kennedy's office.
all righty. All right, so I have Daniel Johnson on behalf of plaintiff, Luke Kennedy on behalf of the defendant. We have a court reporter present.
Yeah, I have not seen Mr. Johnson enter an appearance in this case, so I didn't know he was representing plaintiff.
I do apologize for that. There was one of our attorneys left the office, and I have taken over this case and here for this matter. I'll intend to file that as soon as we're done today. Here.
All right, so this is an issue about workers' compensation and whether the plaintiff's claim is precluded. So, all right, so this is the case 2022 CV 00814, January 15th of 2025, motions hearing before Judge Tammy Long Hayward in the State Court of Clayton County. Madam Court Reporter, are you ready?
Yes, ma'am. Thank you.
No problem. All right, so let's begin.
Yeah, Your Honor, I can go ahead if you want me to.
Yes.
All right. So as I said, I represent the defendants in this case, and we think this is a pretty straightforward legal question for the court to answer. Basically, the question is,
Nothing with comp is straightforward for this court. I've had a ton of these. Go ahead.
fair enough. All right. Well, I'll try to make it as straightforward as I can. But basically, the question is, does the workers' comp bar apply to this case? And then, if so, the court, has to dismiss it because it doesn't have subject matter jurisdiction, basically. So, defendant's position is that the Workers' Compensation Act is the exclusive remedy for plaintiff in this case because he is a statutory employee of defendants who was injured in a work-related activity. And the authority we cite for this is OCGA 34-9-11, as well as Kellogg Co. versus Pinkston, which is 253 Georgia Appellate 190. There's no dispute between the parties that plaintiff was an independent contractor at the time this incident happened, but that doesn't affect the fact that he's considered a statutory employee under Georgia law. So the question really is defendant plaintiff statutory employer, to which the answer is yes under OCGA 34-9-8. That statute imputes workers' comp liability to the entity hiring the independent contractor. So in this case, it would be the defendant. And the whole purpose of that is to protect people like the plaintiff and make sure that there is, workers' compensation coverage for someone like the plaintiff who gets injured on the job. And so because the plaintiff was an independent contractor, didn't carry his own workers' comp insurance, then that would fall onto my client, the defendant. And one of the most important factors for the court to consider is that after we filed this motion to dismiss, plaintiff filed a notice of workers' comp claim against my clients. So they're currently trying to proceed under both workers' comp and...
Well, a recent case taught me it is almost impossible to proceed under both. If workers' comp is the exclusive remedy, then and a lot of it has to do with once you avail yourself of workers' comp as a remedy, even if you would have fallen outside of it and been able to pursue a tort claim. Once you avail yourself of the remedy provided by workers' comp, you now exclude yourself from a tort process.
Exactly. And, there is a process to where you could proceed under workers' comp first to get an award and then later pursue it in state court if, the person is insolvent or there is no insurance or something like that. But that's not what we have here. And it may be the case I don't know if this is the one you're thinking of, but there is a Southwire Co. versus Benefield, which is 184 Georgia Appellate 418. That basically says when an employee's injuries are compensable under the act, being the Workers' Comp Act, the employee is absolutely barred from pursuing a common law tort action to recover for such injuries. And that's basically exactly what's going on here. And they're trying to argue that my clients are not the employer of the plaintiff when in the workers' comp claim that they filed, they listed my client as the employer in that case. And so basically, Judge, you don't have subject matter jurisdiction in this court when the workers' comp board does. In the case for that is, well, you're probably aware, is Savannah Hospital Services versus Scriven, which is 350 Georgia Appellate 195. So we're asking that this case be dismissed, Your Honor. Plaintiff does have a remedy, under the workers' comp to pursue for his injuries, but he can't sue my client for tort damages in state court and then also try to go after my client for work comp damages under the Workers' Comp Act.
All right, Mr. Johnson, you're gonna teach me something today, because the exclusive remedy has a pretty broad footprint in Georgia.
Yes, so first off, under 3491, we can see what the actual definition of an employee is. Section 2 of 3491. Employee means every person in the service of another under any contract of hire or apprenticeship, written or implied, except for persons whose employment is not in the usual course of the trade, business, occupation, or profession of the employer. We argue that he is a contractor. We argue that he is a independent contractor. And the reason for it is he meets OCGA section 3492E. A person qualifies as a contractor if he meets these three following factors. He is a party to a contract, written or implied, which intends to create an independent contract relationship. Has the right to exercise control over the time, manner, method of work to be performed, and is paid on a set price per job or per unit basis, rather than a salary or hourly basis. Now, our client meets all three of these factors as an independent contractor.
I don't think that's the dispute, though, because independent contractors have come under comp before under different schemes. The issue is whether the employer is the contractor-employer relationship is what comes under comp.
I think he was going under 3498A.
Yeah, well,
which he says that a principal, intermediate, or subcontractor shall be liable for compensation under the Act. However, this has been explained by the Supreme Court of Georgia. By its terms, OCGA 3498A provides for a secondary liability for the injured employee's workers' compensation benefit. Only an entity who is secondarily liable for the workers' compensation benefit under OCGA section 3498A is consequently entitled to tort immunity under OCGA 34911. This is recognized in Evans and subsequently in Manning. It is only a contractor who is a secondary liable for workers' compensation benefits and who is therefore entitled to tort immunity. We believe that this applies in this case to prevent Road Dog Trucking from saying that they are barred from by the exclusive remedy doctrine. Council did bring up that we did file a workers' comp case. There is a reason for that, and a letter was sent to opposing counsel by a previous counsel concerning that issue. The reason why is workers' comp gives you 1 year to file a claim in a workers' comp case. And because of the posture of the case and where we were at that time, he felt obligated to file that workers' comp case at that moment to ensure that he preserved the guy's right in case this court were to dismiss their ability to proceed under the tort action.
Okay.
It wasn't trying to double dip or anything of that nature. It was purely to preserve the right because of the time restrictions.
Okay. Well, that is less of an issue with respect to whether I have jurisdiction than whether they were in the positions as contemplated by the Workers' Compensation Act that would allow this defendant to hire a sub and then be in the position to provide workers' compensation benefits for that sub when they were engaged in the business for which they were hired. So just tell me a little bit, is this a trucking company and the plaintiff was hired as a driver?
That's right.
Yes, it's a trucking company. My client was contracted to drive the truck and do deliveries. Issue that you could possibly bring up on a dismissal is you could name every single person that they subcontracted with, if he's a subcontractor, who put anything on that truck. You know, if there's 15, 20, 30 people who had something in that truck, you could potentially say he has 20 or 30 different people to pursue, which doesn't make it effective as far as any legal court system.
Yeah, I have some fairly recent history with these kinds of issues, and I'm going to look back at that. I had a case where I had to not only determine whether workers' comp was the benefit, but also whether another state's laws and workers' comp program was essentially what controlled. And so I'm gonna look at this, but I don't see a path to this being a tort claim. I'm going to look at it more clearly. Like I said, I'm familiar with Scriven, and I've had a couple of cases recently that have been sort of off the wall, and had to make some decisions in those cases with respect to comp, whether the person was indeed subject to workers' comp versus the Tort Claims Act. And so we'll go ahead and look at it and send you an order.
There's another case that we cite, Supreme Court case, Yoho, 263 Georgia at 342. It talks about the ordinary meaning and common usage when designating a statutory employer. I can read it to you, unless it's in our brief as well.
Yeah, I'm clear. Like, literally have had probably 6 cases that have come before me for tort claims that have really had comp issues. A couple on point with respect to people who were hired as independent contractors who were injured while in the performance of those duties as independent contractors. One of which was a trucking company where the driver who was hired as an independent contractor was killed in an accident that happened in North Carolina. So it's a lot of complications, and I understand the plain meaning of the definitions of subcontractor, contractor, employer, but workers' comp and the carve out that it's had with the exclusive remedy has pulled a lot of stuff under that umbrella. So I'm going to look at it clearly and I will issue an order. But yeah, this is not unfamiliar territory. It's just not workers' comp. It's just not my favorite thing. But
I can understand that sentiment.
because I've had experience with it recently, I've read these cases recently, so we'll go back to it and I'll make a decision.
Thank you, Your Honor.
All right, thank you both.
May I be excused?
Yes, you may.
I'm sorry, before you go, Mr. Johnson, what law firm are you with?
Law office Calvin Smith.
Calvin Smith. Okay, thank you. And are you going to participate in takedown?
If you could send me a copy, that'd be great.
Okay. All right. I'll have my office do that. You'll see that from Metro Atlanta reporters.
Right. I appreciate it.
All right. Thank you, Judge. May I be excused?
Do you need my email address?
Yeah, if you have it, I just didn't want to interrupt on the judge's time.
I'm sorry. You okay, Your Honor?
Yeah, go ahead. Give her that.
It's D Johnson at calvinsmithlaw.com.
Thank you.
Have a good day, Your Honor.
All right, you too. Take care.
Thank you, Judge.
All right. Thank you, ma'am. All right, next case is Otonio Soto Morales versus Terrence Jones and Quiness Pai. Is this one of the ones that's rescheduled? Oh, no, this is the 11 o'clock.
Yes, Judge.
Yeah. Okay. So we'll take a brief break. If you are here for a case on the 10 o'clock calendar, I have called all of those cases. And if your case was rescheduled, which is possible because I had about 3 of them that were rescheduled, then let me know and I can update you if you're not sure. Otherwise, we'll be back at 11. Thank you. Yes, ma'am.
Not sure if you called my name already, Your Honor.
I did not, Mr.
Okay. Okay.
Let me see. I'm going to look back at my calendar to make sure yours wasn't one of the ones that was rescheduled. Okay. Okay, I do not see you on the 10 o'clock calendar. Miss Powell, do you know if we have Miss Dupree on an 11 o'clock calendar?
I'm checking now. I don't see her name coming up when I search. Miss Dupree, do you happen to have the case number available to you?
Yes, it's 2024. C is in Charlie, M is in Mary, 01703.
Okay, yeah, that's not us. A CM case is magistrate court.
Well, on the letter, it says in the state court of Clayton County.
CM.
Let me go back because I did file this in state court because we originally came to magistrate court and we weren't happy with the decision that was rendered.
Okay, so this is an appeal?
Yes.
All right.
I have a different number for you if you're ready.
Yeah, go ahead.
2024. C is in cat, V is in Victor, 01480.
I also don't see that, but I'm checking my my notes. I'm gonna check our system right now. I can tell you in like 2 seconds.
Thank you.
All right, I'll be back at 11. Miss Powell will help you, Mr. Dupree.
Thank you.
Thank you.
And Ms. Powell, if you need me to send you a copy of the letter that I received in the mail, I can email that to you as well.
Okay. I think I see you here. Give me 1 second. Oh no, Ms. Dupree, I do see you here. The 15th day of January 2025 at 10 a.m. I am not sure why you didn't pick up on my calendar. And so what we're going to have to do is reschedule your hearing date.
Okay.
But we can do that and then send out notice. We can try to get you the next available hearing date. It's going to be March 19th. So if you want to look out for an order for that day.
Okay, thank you.
Okay, apologies for the inconvenience.
Thank you. Bye-bye.
Mr. Chairman. Give me 1 second. I'm trying to learn how to do this thing. There we go. Okay. How's it going?
It's going okay.
Yeah.
Can you see me?
Yes, sir.
Okay.
Am I on camera as well? This is my first time kind of using this app. Let me see. You can see me?
It's my first
Gentlemen,
time.
you're both on camera, but you should be muted until you're addressed by the court.
Okay, sorry.
You can turn your camera off until you're speaking with the court, or you can leave your camera on. And then, sir, your name is showing up as iPhone 10. And so you'll want to go, I believe it's if you go to your chat feature, you should see the option to click on your name and rename yourself.
Okay.
And you'll want to list your first and last name for the court.
Okay.
I see you though.
All right. You said I should go where and do it? And you say to the settings?
You should be able to click on chat and then see your name. Oh man. Okay, actually, Judge is better at giving the instructions for renaming, so I will leave that to Judge, but she'll tell you when she comes on.
Okay, thank you. Let's see.
Good morning, ladies and gentlemen. This is the 11 o'clock calendar. State
Judge,
Court of
before we get, I'm so sorry to interrupt. Before we get started with the 11 o'clock calendar, could we have a very quick sidebar?
Sure.
I found it.
Just give you a call really quickly, if that's okay.
All right, hold on. Good morning. This is the 11 o'clock calendar, State Court of Clayton County. I'm Judge Tammy Long Hayward. This is courtroom 304. This is the civil motions and hearings calendar. First case on the calendar is Otonio Soto Morales versus Terrence Jones versus Kunes Pike. Is there anyone here on behalf of Otonio Soto Morales?
No, ma'am, this Willie Bell, ma'am.
Willie, you
sorry.
can mute and turn off your camera until she
Yeah.
calls her case.
Yeah, that's
Okay.
not your case yet, Mr. King.
Yes,
All
ma'am.
right, once more. Let's see. Sure this hasn't been rescheduled.
There were some issues with representation in this case, Judge, so it just may be that these parties are not actively pursuing this case anymore. No notice was sent.
I'm sorry?
So there were some representation issues in this case. They may not be pursuing relief anymore, but no notice was sent.
All right, so this case will be dismissed for want of prosecution. Oh, I'm sorry, we didn't send notice for a hearing? Is that what you're saying?
No, I'm saying they did not send notice that they would not, no party sent notice that they would
Oh,
not be.
okay, so this will be dismissed for want of prosecution. All right, Calvary Portfolio Services versus Lasagna Denise Bird. This case has been rescheduled. Next is Abner Wilkinson, Angela Wilkinson versus D'Angelo Harrison and Katrina Carter.
Good morning, Your Honor. Mandy Moyer for the plaintiffs.
Okay, Ms. Moyer. Is there anyone here on behalf of D'Angelo Harrison and Katrina Carter? Harrison Carter. Yes, Ms. Pye, you're free to leave at this time. The case has been dismissed for want of prosecution. All right,
Thank
yes,
you.
so case 2023 CV03718, Abner Wilkinson, Angela Wilkinson, Ms. Moyer, Mandy Moyer is here on behalf of those parties versus D'Angelo Harrison and Katrina Carter. I don't see either of those parties. They're both pro se and I don't see them in the courtroom. Ms. Moyer, let's proceed.
Oh, wait,
Okay.
I'm sorry, Judge. We just dismissed Quinny's Pie, but she was one of the defendants on the Otonio case.
Yeah, because the case is dismissed for want of prosecution, she doesn't have to stay.
Oh, yes. Sorry. Excuse me.
Yeah, unless she had a counterclaim that I missed. I didn't see one.
No, Judge.
Okay, all right. Yeah.
Yeah, Your Honor, we just have a brief, I'm just going to do a brief damages hearing.
Yes, ma'am.
And ask
Who's your witness?
both of my witnesses are here. It's Mr. Abner Wilkinson and his wife, Angela Wilkinson.
Okay.
It shouldn't take more than 10 minutes, 5 minutes.
All right, call your first witness.
Oh, okay. Abner Wilkinson, can you please get in the screen? Can you please raise your right hand? Swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Truth.
Okay. Can you state your name for Judge Hayward, please?
State your name. Abner
So-
Wilkinson.
Okay, you
All
can
right.
put your-
Hold on. Are y'all in the same place, Ms. Wilkinson, Mr. Wilkinson?
It's just that I can barely hear on this
Well, it's
phone.
probably
And if I get
because
too
you-
close to
Probably
Angela,
because you
then
Probably because you
echoes.
have two devices on in the same location, you're probably getting some feedback.
Why don't y'all get on one?
Yeah. Can y'all get together in the same place on one device? All right. And whichever device works best, you can hear me best.
Okay, not Abner, maybe turn yours off, and Angela, we can go on yours, or vice versa, whichever. Okay, perfect.
All right, now, Mr. Wilkinson.
Okay.
You're Miss Moyer,
Yes.
Mr. Wilkinson?
Yes, ma'am.
Okay, that's better. All right, go ahead, Miss Moyer.
Okay. Mr. Wilkinson, tell us a little bit about yourself. Are you married? Do you have any kids?
Yes, I'm married. I have a adopted son. I have a daughter.
Okay. And what do you do for a living?
I own a gutter cleaning and pressure washing company.
Okay. And how long have you owned that?
Since 2014.
Okay. And why are we here today?
Because a guy hit my truck and then ran away.
Okay. And when was this? Just was it the end
This
of
was New Year's Eve,
2022?
2022.
And where were you coming from?
I was coming from home. I was coming from home. I was headed to the mall, actually.
Okay. And just tell me briefly what happened.
Okay, so I was on Waldrop Road or Drive. What was the road? Waldrop Road in Decatur. And in this particular location, it's like a single lane. You know, it's a bridge that you go over, a little short bridge you go over. You know, but it's one lane on each side. And so as we're going across the bridge, from far you can see a guy coming and swerving. He's just driving reckless. And so I got to the point you don't even know. I didn't even know he was gonna make it to me. I was sure he was gonna have an accident before he made it to me. But some kind of way he got back on the road. And so I had a split second to the side. Do I kind of try to make it past him or just stop? And you know, it happened pretty fast, but what he ended up doing was hitting like my driver's side close to the door, like in between the door and the gas where you put the gas in it. And then his truck actually flipped over my truck and went upside down. If I wasn't there, he probably would have just went off of the bridge. So I might have saved his life. But so his truck went upside down and all our airbags just, you know, made the whole truck dark. And you know, once we got it together and gathered ourselves, me and my godson got out of the truck. And I don't know what happened to the screen. Oh, got out of the truck. My godson went to go check on the boy that hit us. So he got out, he kicked out of the truck some kind of way upside down. And then he came towards me, he had like a little blood coming out of his head. My son said it looked like he had a gash on his head. And so I just asked him, was he okay? He said he okay. And he was kind of like out of it, kind of loopy. And then I asked him, you know, once I realized he was okay, I asked him, did he have his insurance and license and that type of stuff? He was saying, nah, man, I can't stay here. I can't stay here. I can't wait for the police. I was like, well, you got ID or something? And then he showed me his ID. I don't know if it was license or ID. I still got a picture of it. And I took a picture of it and then he handed it to me and then he just took off.
So he fled the scene?
Yeah, then he fled the scene. So I just gave the officer that arrived his ID.
Okay.
And that's pretty much where we're at.
And were you injured?
I mean, yeah.
Yeah.
But I didn't go immediately to the doctor. It was like I was just trying to make sure that that my son was okay. And
Okay. When did you first go to the doctor?
I think it was like, I don't know, it might have been, It was January, but I don't remember which day.
And do you remember what the doctor's name was or what treatment facility you went to? Was it Georgia Brain and Spine?
Yeah, Georgia Brain and Spine. That's
Okay,
exactly.
and what was mainly bothering you?
Back, honestly. Like I got bulging discs now. You know, I can't really. Still to this day, I can't really just lay comfortably or stand for a long period of time or sit for a long period of time. I just have to keep stretching and trying to. I don't know.
Okay. Was your neck bothering you?
Yeah, it's a little. It's
Did
not as
the
bad anymore.
did the doctor diagnose you with post-concussive syndrome?
With what?
Post-concussive syndrome?
Yes.
Okay. Now did Georgia Brain and Spine have you go get imaging of any kind?
Yes.
And do you remember where you went to go get imaging?
You know the name of the place?
It was somewhere in Alpharetta. I don't remember the name of it.
I thought it was the same place, but maybe not.
Was it American Health Imaging?
Yes.
And do you remember having an MRI of the brain, the cervical spine, and the lumbar spine?
Say it once again.
Do you remember having an MRI of the brain, cervical spine, and lumbar spine?
Yes.
Okay. And then after that imaging, did you treat anywhere else?
Was it Arrowhead?
We went to the chiropractor, a couple of different places. Arrowhead ended up being the last one I went to. The first one I think was it's the one up the street here in this plaza. Benchmark, I think.
Yeah. Okay. All right. So you treated with Georgia Brain and Spine, American Health Imaging, Arrowhead, and Benchmark.
Yes.
Okay. I'm going to share my screen really quick. Okay. Can y'all see this?
Yes.
Okay. I'm showing you what's been previously marked as Plaintiff's Exhibit 1. Do you recognize this?
Yes.
And how do you recognize this?
That's the medical bill from the doctor after the wreck.
Okay. And is this Georgia Brain and Spine?
Yes.
Okay. And I'm showing you what's been previously marked as Plaintiff's Exhibit 2. Do you recognize this?
Yes.
And how do you recognize it?
It's the same. It's the
bill.
Is it the imaging bill from American
right.
Health
That's
Imaging?
the bill from the doctor. Yep.
We just thought they were all together, but yeah.
Yeah. It's just small, but yep. Yeah, I recognize it. That's the bill.
Okay. And I'm also showing you what's been previously marked as Plaintiff's Exhibit 3. Do you recognize this?
Yes.
And what is it? How do you recognize it?
That's another medical bill.
Is it from the physical therapist benchmark?
Yep.
Okay.
How you doing then?
At this time, I'd like to enter plaintiff's exhibits 1 through 3 as exhibits.
It will be admitted without objection.
And I'm also showing you what's been previously marked as Plaintiff's Exhibit 4. Do your total medical bills equal $15,571.33?
Mm-hmm. I thought it was more than that. Yeah.
Okay. And I'm showing you what's previously been marked as Plaintiff's Exhibit 5. Do you recognize this photo?
I do. That makes my heart stop. Yeah. That was gut wrenching.
Now, is that your car?
No, that's his.
That's his car. Okay. Is this your car?
That's my car.
And is it a true and accurate description or depiction of the state of the vehicles that day?
Yeah. Yeah. I wish my nephew. Yeah, there you go. Yeah.
Okay.
Oof.
All right. I'd like to enter plaintiff's exhibits 4 and 5 into evidence.
Submitted without objection.
Okay. Abner, how has this impacted your life?
Oh, I mean, loss of wages. Again, I haven't been able to. My back is just, I don't even know how to explain, like,
How much are
the
you claiming
difference.
in lost wages? Do you know?
Ma'am,
Do you know how much you're claiming in lost wages?
like 100,000. What is it? I don't know. What is it? Let me look.
We had a previously amount of $30,000.
30,000.
Yes. But just briefly explain, lost wages, how else has it impacted your life?
Well, I couldn't work for until I got another truck, obviously, and then even when I did, now I'm having to pay for it. That truck was paid for. So I mean, not only couldn't I work, but when I was able to get back to work, it's just been the added bills, and I guess it's affected Ann too, because if I can't get no sleep, she can hardly get any sleep.
Yeah.
But and in turn, it's like I can't do anything for a long period of time, whether that's sit or stand or.
So you're still suffering today?
Yeah, so like it's like that's why I didn't understand I couldn't remember which physical therapist, because I went to Benchmark, and then then the money ran out, I guess, and then I tried to go to another one, and if I could, I'd go to one now, but I bought some of their equipment to try to use at home, for me to turn the screen around. Like anything I can do to try to feel better. I don't know. Just my back is really still messed up.
Thank you for explaining that all to us, Abner. Now I would like to just briefly ask Mrs. Wilkinson some questions. So if you could raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Is this a loss of consortium claim?
Correct, yes.
Go ahead.
Please state your name for Judge Hayward.
Angela Wilkinson.
And you're Mr. Wilkinson's wife, correct?
Correct.
And how many children do you have?
I have a stepdaughter that's 20, and then we have an adopted son that's 18.
Okay.
So
and just briefly explain to Judge Hayward how this wreck has affected your relationship with Abner.
Oh my goodness. It's like Abner really made the bulk of our monies. So if he can't work, then I have to work, and then I have to do Amazon, and then now we have.
You kind of froze.
I'm sorry.
Did y'all get
then
that?
I have to work, and he can't work for long. Now we have a new truck note that we weren't anticipating, but he needs a truck to work. It's just been rough. It's affected us. Like, we're arguing about money all the time. So it affects our intimate relationship, just all the way around relationship, because we have to work together. Like, I have to do more, and it's only so much I could do. So it's a strain. It's a lot. Our insurance has gone up. It's just been a domino effect on everything. And then these people I don't understand how you can ride with no insurance.
What, Miss Wilkinson, were you working prior to this accident?
I
was working
was
outside the home.
Yes.
Okay, and did you have to get different employment or additional employment once?
I had to get additional employment. I have to do Amazon, tutor kids a couple of days a week. I have to do things, clean a home or something, do things to make extra money, because we don't really get sleep, because he can't lay down away without just tossing and turning and waking me up. And it's just, my life is different.
Were there things in the household that Mr. Wilkinson did? I hate that men's work and women's work, because I think everybody can do anything they put their mind to, or were there certain tasks that he did in the home that he now can't do or has difficulty doing that you've had to take over?
Just like everything, he used to be able to cut the grass, you know, now I have to get help with the grass. I'll try, but I have to get help, and then you have to pay for help. Like the trash, trees, like a tree fell in the yard. We had a saw, but I had to pay for somebody to come and get the tree so that I could get out of my driveway. Like,
it's all the things you don't think about until something happens.
yeah, like I have to pick up things because I kind of feel guilty if I ask him, or if he does it and he takes you know, I feel bad. And then he has to work, like, but he can't work for long. He has to take more breaks. So like now he's working more days because he can't work so long. Like he don't get any days off now. And then that affects his mood. And I try to deal with it, but it's just like, it's bad.
Okay.
It's bad.
All right. Anything else for Miss McKenzie, Miss Moyer?
You mean Miss
Wilkinson, Miss Moyer?
It's okay. No, that's it. And just briefly, closing, we would ask that Your Honor enter a judgment of $150,000 against the defendants. We believe that number is fair given the pain and suffering, lost wages, and everything that the Wilkinsons have had to go through.
All right. So based on the testimony given, and it's been uncontroverted because my understanding is the service was perfected against D'Angelo Harrison. It was not against Katrina Carter. Is that correct?
Yes, I believe so.
So based on the default that the court is going to issue in this case against D'Angelo Harrison, the medical bills have been pled at the amount of $15,571.33. Lost wages have been testified to in the amount of $30,000. And there was a testimony as to a loss of consortium. There was evidence given that there have been changes in the dynamics of the relationship between Mr. Wilkinson and Ms. Wilkinson based on the accident. And so the Wilkinsons, the plaintiffs, are asking the court to grant $150,000 inclusive of those amounts for compensation in this case. And the court is going to grant $150,000 as pled plus court cost.
Thank
All
you.
right.
Thank you, ma'am.
All right. So Ms. Moyer, if you will get, if you have not already presented an order to the court, if you will get an order to Ms. Powell, we'll go ahead and sign that and get that out to you as quickly as we can. Mr. and Mrs. Wilkinson, you know, I understand. There was a period of time where I wasn't working because we had a medically fragile child and my husband was working, and it does change the dynamics of your relationship when you have something medical going on. But remember who you were before this accident. Remember that trouble doesn't last always, and that you are you're gonna be able to work it out. Okay.
Thank you. Thank you.
You're welcome. All right. You all take care. And thank you.
You too.
Thank you. May we be excused?
Thank you, ma'am.
Thank you.
Thank you.
All righty. Next is Ariela Black versus Adelebu Obeniga and Akeem Obeniga.
Good morning, Your Honor. My name's Madeline Collett, and I represent the plaintiff. Also, lead counsel Ross Worsett is here with me.
All right, Ms. Collett.
I represent the plaintiff. This is a personal injury case before the court in a default posture against 3 defendants, none who have filed an answer or any other pleadings in the matter. Service was perfected on Akeem Obenigba on December 18th, 2023, on Adelabu Obenigba through Secretary of State on December 28, 2023, and on Auto Express of Alabama LLC via registered agent Adelabu Obenigba on March 11th, 2024. And we should just need 10 or 15 minutes.
All right. Present your first witness, Ms. Collette.
Okay. The plaintiff
All right,
calls.
I'm sorry. Let me call the case. So this is the state of Georgia. I'm sorry, Ariela Black versus the parties Lebu Obanigba, Akeem Obanigba, and Auto Express of Alabama. All of the defendants have been served, but did not present defenses in this case. This is a default action, and this is case 2023 CV 03482. All right. Thank you, ma'am.
Hi. Good morning, Ariela. You can unmute. Yeah. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thanks. So, just some introductory info. Please state your name for the record.
Ariela Black.
And tell the judge briefly about what happened to you on January 29th, 2023.
Yes, so I was at a stoplight and I got rear-ended from behind in my vehicle by another vehicle. It was very strong. It shook me, and I just put my stop, like my intermittent lights, to just collect information from the other vehicle. But as I saw, the vehicle just went backwards and drove away, started to drive away. And in that process, I did grab my phone and was able to take a picture of the vehicle and the license plate. And then, I called the police and then also went to the hospital to seek treatment.
Okay, Your Honor, I'd like to share my screen.
You may.
Ms. Light, do you recognize this picture?
Yes, I do.
And can you just describe the picture for me?
Yes, so that is the license plate and the vehicle that struck me.
Okay, and is it a true and accurate depiction of the vehicle?
Yes, it is.
Okay, thank you. What injuries did you suffer as a result of the accident?
I injured my neck pretty badly, and till this day I have extreme neck pain and shoulder pain from the accident.
And did you receive any treatment for those injuries?
Yes, I did. As I said, I went to the hospital, got treatment at Piedmont Hospital for neck pain. I got a CT scan, also went to Northwest Chiropractor, got sessions there, and also got an MRI at Elite Radiology.
And did your chiropractic treatment, what treatment did you get there?
So adjustments, and it did help, but again, I'm still in pain following the treatment.
And you said you got an MRI at Leake Radiology?
Correct.
Okay. And when you went to these healthcare providers, were any records created based on your treatment there?
Yes, they were.
Would you recognize those records if you saw them today?
Yes.
Okay. I'd like to share my screen again and show what's been marked as Plaintiff's Exhibit 2.
You may.
So do you recognize this document?
Yes, I do.
Okay, and what is this document?
That is the record of the hospital treatment plan that I received. The bill.
Okay. And yeah, they're pretty robust. So let me see. I just want to give you a minute to scroll through. And do you recognize this?
Yes.
Okay. And what is this?
The complaints that I had when I got to the hospital, complaining of all the symptoms that I had.
Okay. So are these a true and accurate copy of your medical records relating to this incident?
Yes, they are.
And do they accurately reflect the treatment you received?
Yes, they do.
Okay. Did these healthcare providers bill you for the medical treatment that you received?
They did.
Would you recognize those bills if you saw them today?
Yes, I would.
Okay, I'm just gonna share my screen one more time to show it's been marked as Plaintiff's Exhibit 3. Scroll up. Okay, do you recognize this document?
Yes.
And can you describe it for me?
Yes, it's the bill from the hospital.
Okay, from Piedmont. And can you just tell me, does this look like an accurate depiction of the medical bills you received?
Yes, it does.
Okay. And this is, can you tell me about this document?
Yeah, so that's the bill from the Elite Radiology.
Okay. Thank you. Can you briefly describe some of the ways your injuries have affected you and your lifestyle?
Yes. So it's extremely hard to drive for more than like 20 or 30 minutes. It's really painful to sleep. It's really painful. Just anything to do with my neck, just moving it to side, things that I was able to do before. So I'm just like kind of really constantly in pain. My motion is just depleted, and yeah, it's just hard to do any type of physical activity. And just while driving too, I think it's, I get scared at stop signs, at stoplights, because I feel like it's going to happen again.
Yeah. Yeah, thanks for sharing that, Ms. Black. I don't have any further questions, Your Honor. At this time, I would like to introduce into evidence Plaintiff's Exhibit 1 through 3.
Will be admitted without objection.
Okay, that closes our case in chief, Your Honor. Our total request for the plaintiff Ariela Black is a judgment in the amount of $308,749 against defendants. This is based on medical bills in the amount of $8,749, claim for punitive damages for the hit and run nature of the incident in the amount of $250,000, and pain and suffering in the amount of $50,000.
Okay. All right. This case having fallen into default because the defendants were served but did not defend, the court is going to grant the amount that is uncontroverted based on the testimony presented today, $308,749 plus court costs.
Thank you, Your Honor.
All right, go ahead and present an order to Ms. Powell for them.
Okay, will do.
All right, Ms. Collette, thank you.
Thank you.
All right, next is LM Insurance Corporation versus Trevor Bacon.
Good morning, Your Honor. Deanna Smith here on behalf of the plaintiff. The judges, or you have previously entered default as to liability. I have Craig Shea here as my witness, and we shouldn't need 3 minutes of your time.
All right, Mr. Shea, your screen is black. That happens when I don't push that little lever on my computer. So if you know how to either share, open your screen so I can see you, or I kind of like slide the little thing on your computer.
I'm here, but I've got video. It shows that the video is going, but I've had some issues in other meetings where it's blacked out and I can't figure out how to get it off.
Okay, let me ask you a question. At the top of your screen, when you run your hand at the top of your screen, where the camera is there a little lever? Can you feel a little nodule?
There you go.
Yeah, that's better.
I do tech.
Look how easy that is.
Do tech. That's okay. That's free information because that's how I figured it out. It's like,
all
what
right.
is going on?
I can help some coworkers because theirs was the same. Thank you.
No problem. All right. So, sir, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, Your Honor.
All right. Your witness, ma'am.
Thank you. Craig, where do you work and what is your title?
Liberty Mutual Insurance Company, and I am a RNS, which is a program manager for collision centers.
And for how long have you been employed in this capacity?
I've been with Liberty Mutual for 18 and a half years, and I was also a state salvage inspector for 8 years as well, looking at total loss vehicles that were repaired to be put back on the road. So more or less a safety inspector.
Okay. And so do you have training and experience in evaluating property damage to vehicles?
Yes, ma'am.
Okay. And are you familiar with this loss that occurred on September 4th, 2021?
Yes.
All right. Your Honor, at this time, I'm tendering Mr. Shea as an expert witness.
The court will admit him as such.
Craig, can you please tell me what type of vehicle LM insured?
Yes. Hang on. Let me get to I think it was I've got to get to my fact sheet. 2014 Chevrolet Equinox.
Okay. And can you tell me what the fair market value of this vehicle was immediately prior to the collision?
Yes. 21,514.66.
Okay. And was this vehicle a total loss or did LM pay for repairs?
No, it was a total loss.
Okay. Did they get any salvage recovery?
Yes.
In what amount?
$2,528.14.
Okay. So the difference between those two amounts, do you have that?
Yes, ma'am. It's $18,986.52.
Okay. And did LM pay for a rental car or loss of use while the vehicle was being determined a total loss?
Yes, loss of use was $906.75.
Okay. So what is the total amount of damages LM is seeking today?
$19,893.27.
And is that amount fair and reasonable in light of the damages and your experience?
Yes, ma'am.
Thank you, Craig. Your Honor, at this time, we are also asking for prejudgment interest in the amount of $1,173.15. This was calculated pursuant to OCGA 51-12-14. We sent the defendant was personally served on March 17th. The EOS wasn't filed until May 25th. 30 days after that was June 24th, 2024. It has been 205 days with nothing from the defendant. The daily interest rate is $5.72. That times the 205 days is $1,173.15. We're also asking for attorney's fees in the amount of $1,500. I submit to the court that my time on this case took approximately 5 hours, and that's my reviewing, my filings, my prep work, and my time in court. And $300 an hour is a reasonable and customary rate. We also asked for attorney's fees in the original complaint in paragraph 5. We're arguing that the defendant has caused plaintiff unnecessary expense under OCGA 13-6-11, as well as costs of court. And I did email Ms. Powell a proposed order around an hour ago.
Okay, and what is the total that the plaintiff is seeking in this case?
Well, I didn't total it, but the breakdown is the principal is $19,893.27. The prejudgment interest is $1,173.15. The attorney's fees is $1,500. And they're all separated on the proposed order. I just don't have the total.
That's fine. Okay. All right. So the plaintiffs haven't come before the court in this case where default has been granted. The defendant was served, did not respond, has not appeared for the hearing to challenge the amount of damages. Damages were pled and proven in the amount of $18,986.52 for the post salvage loss from the vehicle. The rental or loss of use was $906.75. So that is a total of $19,893.27. And the court will also grant $1,173.15 for prejudgment interest to OCGA 51-12-14. And $1,500 for attorney's fees under 13-6-11 as pled in the complaint. The amount is found to be reasonable based on the amount of time and the rate at which the attorney bills plus court costs.
All right. Thank you, Your Honor. May we please be excused?
Yes, ma'am. Thank you.
Thank you.
Judge, position 7 should be easier to knock out than position 6 if you'd like to move forward to that case first.
Okay, position 7 is the last one before the end of the calendar. So let's go ahead and do Willie Bell versus Yvonne Williams, and then I'll come back to position 6. I'll give
Judge,
you one more time. Yes, ma'am.
it's the courtroom is empty. Can it be shut
Yes,
down
ma'am.
to?
I'm sorry. Yeah, you can release her. Deputy, we'll be back up at 1 p.m. I'm not sure if anyone will appear in court, but we do want to keep it open until I at least call the calendar. And then if they're not there, I'll release you after that. But thank you. We'll see you at 1. All right. All right. So Mr. Henshaw is before you're representing Mr. Willie Bell in case 2024 CV 01616 versus Yvonne Williams, who's pro se. I do not see Ms. Williams in the courtroom or on the video.
I'm here.
All right, Ms. Williams, where's Ms. Williams?
I'm right here.
Okay. All right, Ms. Williams, hold on a second. Is that correct? All right. So, Ms. Williams, I have that you were personally served on August 3rd of 2024. That you did not file an answer in the case, and a motion for default was filed on November 6th of 2024. The order for judgment on default was on December 10th of 2024, and a hearing was set, this hearing, for damages. So since you're in a position of default, you cannot allege that no damages are due if the plaintiff pleads damages, but you can challenge any damages that are presented if you have evidence to the contrary. Do you understand?
Yes.
Okay.
Yes,
Let me be more clear. So you were served personally with a summons and complaint. You had a certain amount of time to respond in writing to the court. You did not make such a response. Because of that, they win their case by what is called default. Because they won their case, but their damages are not such that I can just say this is the correct number based on the paperwork. They have to come to court now to plead damages. Those are called unliquidated amounts, which means they have to bring somebody to show evidence of what has been, what the damages are, and then the court has to make a decision to grant those damages. If you have any thing that would change the amount of damages that you would like to testify to, I will allow that. If you have any evidence you would like to present, I can allow that, but it doesn't change that a judgment will be entered against you in this case. Do you understand?
Yeah.
Okay.
Yeah.
The time to have fought the case in and of itself would have been when you were given the opportunity to answer, okay? And I think a lot of people don't understand that when somebody comes to your door and serves you with paperwork, you got to read that paperwork carefully, because the summons tells you, hey, you're being sued. You have 30 days in which to respond, and this is where you should respond. So all of that information should have been on the summons, the paperwork that was attached to the complaint in this case.
Okay. I didn't see. I don't think. I thought that I was just supposed to have been sent a court date. That's what I thought this was.
No, ma'am.
about. I didn't know it was.
If you were served, you have to respond. Okay. Otherwise, they win. And I don't understand. A lot of people don't get that, but it's in the paperwork that you're served with. Okay. All right. So, Mr. Henshaw, thank you for giving me the opportunity to kind of explain this situation. Now, you're here on behalf of Mr. Bell. You have a witness that you wish to present.
Well, Your Honor, I apologize, and maybe we need to take up another matter first. But Mr. Bell was on here.
I saw him.
And then I don't know if his phone died or something. I'm trying to reach him. I'd like to try to call him real quick, and then see if I can reach him. And if Your Honor wants to go ahead and take up other matters, we're fine.
Well, I have one more. Rashida Leake versus Griselda Mora.
Because he knew he was wrong.
All right, I have Rashida Leake, who's pro se, versus Griselda Mora, who's pro se. Ms. Mora.
Hi, good morning. How are you?
Okay, I can't hear you on the one device because you got two devices.
I do have two devices. Unfortunately, my audio is not working on my computer. Are you able to hear me?
Yeah.
Awesome, thank you.
And I can see you. All right. So, Ms. Leake.
Yes, ma'am.
So this is the case 2024CV02018. This is an appeal from Magistrate Court for a dispossessory. Is that correct?
Yes, ma'am.
All right. So are you still in the property or have you left the property?
I left the property. She had gave me 60 days to leave.
Okay, so this is an appeal as to a judgment.
Yes, ma'am.
All right, and Ms. Mora, you have possession of the property, is that correct?
I do.
All right. All right, so go ahead, Ms. Leake, and tell me what is going on. It is my understanding that there was a damages amount of $4,575 from the Magistrate Court.
Yes, ma'am. So I was living in the property for 6 years. The previous owners, one of the wife had passed away, so the husband sold the property. However, Ms. Mora allowed me to still stay there. She gave me a lease for 6 months and the price of $70.75. And if I needed more time, I can stay there. So came January, I still needed more time. She let me stay there for another 6 months without a lease, but she told me that she would charge me $1,100, which was fine. Came July of 2023, Ms. Mora told me that she was going to, I guess, reconstruct the property, and that I had 60 days to move out. Let me back it up. Prior to me moving in there in 2017, I moved in the property as is, meaning that the carpet was old, I got it clean, no new painting, the appliances was very outdated, countertop very outdated. The owners at the time let me do the countertops over. I did carpet cleaning, I wiped the walls down, you know, fit enough for me and my daughter to live in. Okay, so let's go back to July of 2023. When I was told that I had 60 days to move out, I went and go seek housing for me and my child. And I wanted to hurry up and do it before my child went back to college in August because I knew I was going to need the help. So I found something. The agency told me that I would have to pay, you know, the deposit to move in. I did that and I went straight ahead and moved out. I had a week to move out because my daughter was going back to school. And like I said, I was going to need the help. Ms. Mora still wanted me to pay the rent there. So I told her, hey, I had the money to move out. I didn't have the money to pay you another month of rent.
Okay,
you already gave me.
Hold on.
Okay.
Slow down for me because I need to understand. So Ms. Mora gives you a 60-day notice to leave.
Yes, ma'am.
Okay. And how long after that did you move out?
I found something in the beginning of August, so it was like maybe 30 days. Within 30 days, I found a place.
So what was she charging you for?
She wanted to charge me another $1,100 for another 30 days. But like I said,
Hold on. Ms. Mora, you asked her to leave. You gave her a 60-day notice, which is required when the person doesn't have a lease, but they're working under a previous lease or the previous lease terms. The landlord is required to give a 60-day notice, and within that 60 days, if the person leaves, why would you then charge her for an additional month?
So there's gaps in her story. So do you want me to say my side of the story? Or do you want to finish until she says it? Because that's not exactly how it all went down.
Okay, let me hear the rest of Miss Leake's story. Okay, Miss Leake. So August 2023, you find the new place, and you said Miss Mora wanted you to pay another month.
She wanted me to pay from August to September.
Okay.
Another month of rent. So the money that I had to move was to move because I had to move because I didn't want to be homeless within the next day, paying her and then trying to pay a security deposit for a new place for me to stay.
Okay.
So as I was moving, I'm trying to hurry up and do everything. And she had reached out to me like, hey, you have to pay the rent. And I'm like, oh, hey, by the way, I found a place. Because prior to that, she had signed.
Hey, let me ask you this. Had you paid the rent for July?
Yes, ma'am. I paid the rent for July.
Had you paid the rent for August?
I didn't pay no rent for August.
But you were still in the place in August?
Well, I had moved out. I had moved out August the 5th.
August 5th?
Yes.
Okay.
Yes. So she had signed as a reference for me for my new place. So she already knew that it was getting close to the work because she had signed it for me. So August the 5th, she reached out to me and she said, hey, you haven't paid the rent. And I was like, oh, I got the place. I'm just talking to her because she was so nice to me the whole time I was there. I'm like, I got the place, like excited, because I know I don't have to wait and figure out if I'm going to be homeless or what the case.
I got that, but did you move on August 5th or you moved
Yes,
after?
I did. I moved. Yes,
so all your stuff was out of the place.
I got everything out there the same exact day. I think it was the 6th. I'm sorry. The 5th and the 6th. Yes, ma'am. Okay. So rent is normally due on the 5th of the month.
Okay.
And I moved everything and she was saying, well, if you don't give me the money by this time, I'm going to have to take you to court. I'm like, well, I had to move. Like, I didn't want to be homeless. I wrote her a letter and everything like, hey, this is what's happening. On this day of August 2023, me and my daughter, we both signed the paper and said that we was moving out the place. I found the place. I knew you knew it was coming because you gave me 60 days and also you saw it as a reference for me to move into, so I can go to the next place. And it got approved. And then after that, I had got papers from the court saying I had to come to court. And it wasn't even for the $1,100. It's like she wanted me to do remodeling on the property. And I was so confused about that because I didn't do any damages to the property. When I moved out, I took everything out. I cleaned everything. Anything that was left in there was stuff that was from the prior landlord that he had there when I moved there. And I didn't touch it because it wasn't mine. But like I said, appliances outdated. The townhouse was outdated. I just made it fit for me to live in.
All right. So what else happened?
I can't hear you. Went out.
I'm sorry. What else happened?
And then I got the papers for me to come to court.
Okay. And what was she claiming were damages that you had to pay for?
She had it on there for like the appliances. I can't recall everything they had. The court said they was going to everything over, but basically it was like up to like $7,000 worth of damages for the house, and it wasn't no damages. No.
Okay, were there holes in the wall?
No, ma'am.
Okay, did she allege that you had put holes in the floor?
It wasn't no holes in the floor. I don't know where her damages
copper missing?
Nothing missing.
Light fixtures?
Nothing. Everything was still as is. I moved in 2017. All
right, and how much did the court grant in this case? 4,000. What now?
No, the whole thing was like 7,000 and something. I don't have the whole dollar amount, but I know it was over 7,000 versus me paying $1,100 for a rent for 1 month.
All right. Okay.
And then she also had security deposit that the prior landlord gave to her from me after he gave her a reference to ask if I can stay into the property.
Let me ask you this. So with the security deposit, Did she give you the opportunity to do a walkthrough with her so she could do a list of all the things that were damaged?
Were you saying a walkthrough the last day? Or
No.
walkthrough when you bought the property?
When you told her I'm moving, did she send you notice that you could do a walkthrough of the property with her?
No, she just sent me a message saying that.
Did you ever receive a list of damages from her prior to coming to court?
No, ma'am.
Okay. So then she used the security deposit that you had as damages in this case?
I think when the court summed it up, they had put the security deposit in there and minus it from what she was asking for.
Okay, and how much was the security deposit?
It was $775.
All right. So let me ask you this. So did she ever send you a notice to either your address at that place and it got forwarded to you, or to the new address that you had the opportunity to walk through the property with her to determine if there was any damages?
No, ma'am.
Okay. And did you receive anything from her after you moved out that said, these are the damages I walked through and saw, so this is how much of your security deposit I'm going to keep?
No, ma'am.
Okay. All right. All right. Is there anything else you want me to know?
No, ma'am. That'll be all.
All right, Ms. Mora.
So I just, I'm kind of flabbergasted by what was stated. Nonetheless, I don't see that a judge would have granted me the amount that I was.
Be in magistrate court. A lot of judges don't know about the security deposit. And if they don't look, they might not realize it. We're not infallible. But under section 44-7-33, there's an actual procedure by which you have to go through to document damages, to keep her security deposit, to determine any other damages.
I did everything as the Georgia law stated. So on July 7, 2023, she was provided a 60-day notice. It was emailed to her on that date. It was certified mailed to her. All these docs are actually in the file that was submitted on the magistrate court. And also the hard copy was also put in her mailbox, which also I have pictures of.
Okay.
So this was all provided to her. And as you can see on the file, I have the hard copies here as well. So this is a 60-day notice that was given. This is the courtesy email notice that was given to her. And this is the certified priority mail express that was delivered to her door. And also I went and drove over there and I also placed it in her door.
Okay, so she's not arguing that you didn't give her the 60-day notice. I think she's her argument is about the damages.
Right. And so furthermore, on the email, I also stated a move-out inspection is optional, must be requested in writing, and must be completed 7 days prior to September 5th of 2023. The $750 security deposit per the rental agreement is to be returned within 30 days rental agreement has terminated. Less any damages, security deposit shall not be credited towards rent unless the landlord gives written consent. 60-day notice to vacate is attached. I will stop by the property this afternoon before 1:30 and hand deliver you the notice. If you are not at the property, I will make sure to post it on the door. Lastly, the 60-day notice will also be mailed first class. So this was provided to her via email. To the
and what was the date at which she had to do the move-out inspection? Give me that part again.
September 5th.
Okay.
By 2023. I gave her the 60-day notice on 7/7, right?
Okay.
It allowed us ample time to do it September 5th.
Okay.
So she never responded to the move-out inspection. I then get a text message on August 6th stating that she's moving out of the property. I told her that I provided her with a 60-day notice, and per our agreement, it clearly says on here that This agreement shall be month to month, beginning on July 7, 2022, at the end of any time the landlord or tenant providing at least 60 days written notice to other parties. So I gave her the 60-day notice. Not one time did she convey to me that she was going to move out prior to those 60 days. How she conveyed that to me in a written notice, then I would have been okay with that.
Ma'am, I think you're confused.
In regards to what?
She's frozen. Everybody frozen? Or is it just me?
I'm here.
You're frozen.
Judge. Everyone's moving for me.
I think we had a glitch. So at the point that I left, Ms. Mora was explaining that she gave her a 60-day notice. Ms. Mora, I think you're confused. So you're saying I gave her a 60-day notice, and in your mind, she wasn't supposed to move out until the 60th day. But that's not how this works. If you give her a 60-day notice, she's required to have 60 days before you can take any legal action to remove her, such as bringing an eviction. But it doesn't mean she's bound to stay in the property and to pay the rent for 60 more days. It just means that's the amount of notice that she needs to give, that you need to give her prior to taking any action. You got me?
Right, I understand that.
So when you say she got 60 days and she never told me she was moving out before the 60th day and I want her to pay this last month of rent, it doesn't work that way. So and you say that y'all had a written agreement for her to stay. That sounds like a lease.
We did have a lease.
But in it, you agreed that each of you would have, instead of 30 days, you would each give each other 60 days notice. That's the only change to the lease. You just said we had in writing that I would give her 60 days notice and she would give me 60 days notice.
I never said, I'm sorry, no. So the lease agreement
what you just said.
The lease agreement is here. This is a month-to-month lease agreement.
I get, you can't have a month-to-month lease agreement. Either you have a lease or it's month-to-month. You can't do both. Month-to-month means Month, no ma'am, you got something in writing. Month to month means nothing in writing. We're traveling under the old lease terms, and it's year to year or until I give the 60 days notice or she gives the 30 days notice. That's month to month. Lease means y'all sat down and talked about this, came up with some agreement and wrote it down. And you have from from July of 2022 to July of 2023, there's an agreement in writing. You just said.
So I guess that's my error. So this is considered a month to month. So
No, ma'am, you can't say that. If you have a writing, if you have a written document, it's not month to month. You have just given her more time than you would generally give her to move out. You gave her 60 days. See, this is what happens when non-business people try to do things legalistically and they mess themselves up. So I'm listening closer because I did 4 years in magistrate court. I have combed through every part of the dispossessory code, and I teach it at new judges training. So when I tell you, you can't say to me, it's month to month, but we have a lease or a written agreement. It's one or the other. It can't be both.
That's fine, and I'm not going to harp on that. That's fine. However, because I'm really, the court judge granted me the damages. So
okay,
when I took,
but I get to look at it de novo, which is Latin for as if everything is new. I get to hear all of it, and my decision based on what I'm hearing, nothing to do with what the magistrate judge heard. Okay. Don't care. Okay.
Gotcha.
So
okay.
But I would suggest as a business person that you sit down with a lawyer who is knowledgeable about dispossessory law and clear it up, because you're talking about month to month with written lease terms. That's not how this works.
Got it.
Right?
Thank you.
Now let's get back to the damages, because really she's out of the property, so all of that is under water under the bridge. What I need to know is whether you gave her the opportunity for inspection. She moved out earlier than September. Was there an opportunity for her to inspect when she moved out? Like, did you send her an updated notice?
No, I did not send her an updated notice. She texted me, and the text said that she will go ahead and vacate. She's vacating, and then she would leave the keys in the mailbox.
Okay, so at that point, when you knew she was vacating, did you say, hey, I'm going to do a walkthrough? Because presumably if she's out in August, you're going to try and rent before the September. You're going to try and get somebody in there. So she's not going to do an inspection with somebody else in the property. At that point, did you update your notice to her about the inspection?
No, I did not. There was no further communication, but through the courts when I went ahead and filed. So there was no further communication.
Okay, and then when you went in and decided all of these things that you were going to seek as damages or that she needed to repay you, did you send her a detailed list of all of these things before you went to court?
There was no forwarding address.
No, ma'am, it doesn't matter, because the law says you send it to the last known address. You let the post office worry about whether it gets forwarded.
Got it.
So
no,
you're talking about how you did everything by the law. The law says you can use the last known address. If it gets forwarded, it gets forwarded. If it doesn't, it doesn't. But did you send any communication?
No, there was no further communication.
Okay, now tell me about all of these things that you feel like she should have paid for when you bought the house as is.
Okay, so I bought the house as is, and I did do a walkthrough with her. At that time, there was no pet. She had a pet in there. Were holes.
Okay, hold on. Did you document the walkthrough that you did with her when you first came in and she was attorneying to the lease? Did you document it?
I did document it. I
Did
did a
copy of it?
I sure did.
Okay, did she get a copy of that?
She signed it.
Okay, but did you give her a copy of it?
Via email? Yes, I did.
Okay, so now tell me, when you walked through after she left the property, what did you determine she should have paid for?
Okay, so there's holes in the window screens, right?
Okay.
There were cut out lines, as you can
There were
see
what?
here in this. Hold on, I'm trying to get it so that you can see it.
Okay,
They
so
were
the blinds were messed up. Okay, next.
purposely cut. They weren't just messed up. These were
It was
like
mine.
Okay,
Can
go
you-
ahead, Miss Mora.
the blinds were actually cut. The window screens were completely off on all of the rooms. You can clearly see that they were holes. There were dog bites at the bottom of the blinds. This is the sliding door blinds. There were dog bites at the bottom.
Okay, did you
The
tell her
hand-
she couldn't have a pet?
There, it was written into the agreement or the month to month. There was
It's the
no
lease,
pet-
ma'am. It's not a month to month.
Sorry, the lease.
And
that was
she was
written-
not to have a pet.
She was not to have a pet.
Okay, what was
Um,
hold on. Slow your roll. Okay, if she had a pet, was there a penalty that she had to pay?
Yes, there is. It's right here. $350 pet fee, $350.
Okay, a one-time $350.
Yes.
Okay, go ahead.
Okay. So there were. Hold on, I'm looking for. The closet doors, there were glass. Both of those were cracked. I don't know if you can see that well, but they were both cracked. And all of this stuff was submitted. As you can see, the door knob on one of the bedroom doors would look like it was kicked off or kicked out from the thing. Hold on just a second. The electrical outlets have been damaged. There was paraphernalia found on the apartment.
What do you mean
The smoke
paraphernalia?
Paraphernalia. There were Swisher wrappers and marijuana found in one of the kitchen cabinets, which I have a picture of. This right here is the smoke
Okay,
detector that was.
how does the marijuana paraphernalia damage you?
It had to be cleaned out. It had to be disinfected. All of the.
I hate to say this, but have you owned rental property before?
Have both
Have
here
you
in Canada.
listen to me. Have you ever heard of turnkey costs?
I have, but there's
Okay.
because of the odor, they have to do a special treatment for that. That's just like
I'm
when you rent a
clear.
car.
What I'm saying to you is I'm real familiar with rental property. Don't ask me how I know. Real familiar. But turnkey costs on average are from $3,000 to $5,000, depending on how long the person lived there. Generally, carpets need to be replaced, floors need to be redone, painting needs to be redone. Certain things may have to be replaced, doors, windows, window screens. So all of this stuff that you're claiming is under the list of things that have to be done to turnkey a place to put somebody new in there. I don't know how you feel like this is not a cost that the landlord should bear.
All of these damages that I just pointed out, like
yes,
the smoke
ma'am.
detector-
Because when you talk about window screens and blinds and stuff like that, that's normal wear and tear for somebody who's lived in a place 6 years. Window screen and blinds, those little blinds, you're buying rental grade blinds. You didn't buy them, but the previous people did. You're not buying high-end stuff. You're buying rental grade. And when you buy rental grade for a rental property, it needs to be turnkey. So all of this stuff it seems like you're taxing her for something that, first of all, the people who did it the first time this was not a high-end property. Some of that stuff she may have purchased out of her own pocket as an agreement between her and the previous owner. You don't know because you took over after she took the property. How long was she in the property, Ms. Mora, before you took over?
I don't know.
How long was she in the property, Ms. Mora, before you took over?
I don't know.
Okay, so you don't know if any of that was purchased out of her own pocket.
It was not, because when I did the walkthrough, she never spoke upon it. She never spoke in regards to any repair that she had done. The repair that she did was to change a toilet valve inside, which I reimbursed her for it. Thereafter, she did not point out anything that needed to be repaired. You cannot justify having a hood range to like this after I did the walkthrough. You can't justify my smoke detector being uninstalled. You can't justify the cabinets. You cannot justify the warped cabinets after I did the walkthrough and that was not on there.
Okay, did
So
she,
regardless,
the
I'm sorry,
damage,
what was that?
damage to the cabinets, did she report the reason for the damage to the cabinets?
She did not report absolutely nothing from the time that I did the walkthrough with this lady up until the time she moved out. The only report that she made was a toilet valve that she replaced, which I still have the text for that. And I went ahead and credited her for her purchasing that.
Okay.
So time after I did the walkthrough was my stuff looking the way it came out to look after she moved out.
So how much did you spend to turnkey the property?
What's that? I have all of my individual receipts. Let's see. It could have been. I mean, I have the. I mean, the basically out. It was around more or less whatever I put the amount for when I originally did the court claim, which was, I think it was close to $7,000. Right here it goes, $7,410. That's what all of my receipts added up, and I also asked for the court costs to be reimbursed.
Okay, and you kept the $775 security deposit.
Correct.
Okay. All right. What were the most expensive items that you had to replace?
The most expensive items, let's see, hold on, I have my receipt. The bathrooms.
Mm-hmm. What did you have to replace in the bathroom?
The carpet, I understand that's prorated because she was in there. I also replaced the carpet.
Okay, no, carpet is turnkey, ma'am. I'm not giving you anything for carpet.
Right, that's fine. So basically it was the kitchen area.
What did you do in the kitchen? What did you do in the kitchen?
Do all of the cabinets, and I have pictures of all that.
What do you
stuff,
mean
and I have my
do all of the cabinets? What do you mean do all?
The cabinets worked. All of the doors and the inside of the cabinets that were warped with the stuff that she left behind there, and also the bathrooms. The bathrooms were the same thing. The vanity, I had to replace them. I had to replace the toilets. I had to replace the kitchen countertop. I had to replace all, I don't know if this is included on the turnkey. I had to replace all the appliances. I had to replace the refrigerator, everything you can think of. This is the stove top where she left. It was literally burning a hole onto the dripping pan on the stove.
So you can buy dripping pans separately. Those are about $4 or $5. So why did you have to replace the entire stove top?
Because the stove top, let me show you what it looked like. This is why I had to replace the dishwasher because it was not working.
Okay. Ma'am, Ms. Leaks, how long did you live in this property?
I lived there since 2017.
And Ms. Mora, how long did you own the property?
I purchased the property on 2022.
And did you put any new appliances or anything into the her living unit when you purchased the property?
I did not because there was nothing.
No. Listen to me. Did you paint when you moved in, when you purchased the property?
No, because there were
Did you
no
replace
damages.
Did you replace the flooring when you purchased the property?
No, I did not because there were no visible damage at that time.
So at this time, you've already received the $775 for the security deposit. Ms. Leaks owes you $350 for the pet damages. And the rest of that is turnkey, because you would have had to do all, she's been living in that place for 6 years. When you bought it, it had all of those old appliances. It had the old fixtures. It had, no, Miss Mora, I don't care if there was no damage when you bought it. It is a place where a renter has lived for 6 years. There's gonna be holes in the windows, screens. There's gonna, ma'am, when I tell you I am experienced in rental property, not just from being a magistrate, you're trying to put your turnkey cost on the back of the tenant. Yes,
Absolutely not.
And you probably did that before.
Absolutely not.
Yes, ma'am.
Absolutely not.
Yes, ma'am. And she's not required to pay the additional month's rent. You gave her 60 days to move out before an action could take place. She moved before the 60 days, so she's not, you're not entitled to the month's rent. She moved within the time period that you asked her to move.
I'm not disputing that, but that's already been established. I'm here because at the time of the move-in, the condition of the unit was not as she left it when she left. And regardless of normal wear and tear, this was beyond normal wear and tear.
Okay. So you said the bathrooms, the cabinets, you had to replace all of those. What else was the most expensive thing you had to do?
The most expensive things were the bathroom, the kitchen, I had to literally do everything. So I don't know where that falls in your
Miss Mora, I'm just not impressed by that, because you bought an old property. The person was already living there. There was already going to be issues because you had a tenant in the place. Every time you bring in a new tenant, there's going to be some turnkey, especially when they've been living in a house that long. You bought a property and you didn't replace all of that stuff when you bought it. So what you're dealing with is a tenant who's already dealing with old appliances, old, and all of that. That's all part of being a landlord, ma'am.
Just because things are old does not justify her messing them up to where now they're inoperable. When we did the walkthrough, those items were not like that. Had those items
did the
been
walkthrough
like
in 2022, it's 2025. Had you been in the
Right.
property since then, Ms. Moore? Had you been in the property since then?
Say what?
Had you been in the property since 2022?
No, because she never reported it.
Did you do periodic inspections?
No, because she didn't never reported anything.
It doesn't matter. You have the right as the landlord to do periodic inspections. And if there's issues, then you can address them at that time. But if you went from 2022 to 2023, 2024, you never even went back to look to see if there was damages. And you're saying that it should have been pristine from the time she first started living there, or from the time you bought it until the time she moved out.
That's not, I'm not saying that it should have. I just want what's fair.
And I'm gonna give you what's fair. And what is fair, I think, is about $1,500 to $2,000, because other than that, all of that stuff is stuff you had to do anyway to bring in a new tenant. That's the cost of doing business as a landlord. And I also know you're going to take it off on your taxes, because that's how you run a business. So what you're looking at is a double recovery, when these aren't things that you get from a tenant, especially when you're not doing periodic inspections and you can't follow the decline of the property. Now, if you told me at some point you were in there looking at it, but when we're talking about blinds and window screens, that is the cost of doing business as a landlord. And if you haven't ever had to replace stuff like that before, you're not doing it right.
I don't understand. So it's okay for an individual to rent someone's property and purposely cut blinds. That's normal wear and tear. You're telling me that it's okay for an individual to have your dog bite the bottom of someone's blinds. You're telling me it's okay for someone to remove the smoke detector and then it probably can cause a fire due to you not having the install smoke detector, you're telling me that it's okay for her to have rust at the top of the stove that she supposedly had cooked in? You're telling me that it's okay for her to have rusted the refrigerator?
Ma'am, those refrigerators were old. You don't even know when they were purchased. So rust on a refrigerator, or rust on a stove, you don't even know when they were purchased. So you didn't purchase them.
I seen it in 2022 when I did the walkthrough. It was not like that. That's what I'm trying to tell you.
I don't care. That was 2022. This is 2024 you're talking about.
So you're saying it's okay for her from 2022
Miss
to the
Mora,
time she left
I'm
my
not
stuff.
I'm not gonna argue with this. Tenants do all kinds of crazy stuff. I will grant she shouldn't have had a pet. You're charging her the $350 for the pet. I will grant you've kept her to her $775, even though you didn't send her, you didn't update your inspection requirements once she moved out of the property. You set them thinking that she was required to stay in the property, which that makes no sense to me. You give her a 60-day notice and you think on the 60th day she's gonna move out on that day into a new place, instead of you're giving her the notice for her to within the 60 days move. Then you didn't update your inspection procedures, and inspection notice. You didn't send a damages report to the last known address. In some cases, she might even be entitled to triple her security deposit because you didn't do it right. Even if you go through the process of doing a damages walkthrough after the person has left, if you're going to keep their security deposit, according to the law, you're supposed to then send the damages report to their last known address. You say you didn't send it, but you're asking me what's fair about a property where you bought it with old appliances in it, you didn't inspect periodically, and you want the court to give you the cost of turnkey. Not going to do that. At this point, I will grant you the $775 and the $350 for the dog. I will grant you the $775 and the $350 for the dog. The rest is the cost of doing business.
So what is the total? You said $775 and the $350?
And you've already gotten the $775 because that was her deposit, and the $350 she'll pay that.
Okay, so can I have that paid? Can you give her a date to have that money rendered to me?
I don't generally do that because it is your job to collect it.
I'll garnish her
Once
wages, not a problem.
Once I give a judgment, it is upon the person who prevails to collect the judgment. But Ms. Mora, sit down with an attorney who's knowledgeable because everybody who thinks they know the law, well, I'm doing it by the law, and you're telling me it's month to month when you clearly have a lease that you've negotiated. So sit down with somebody.
Well, this is a lesson learned here in Georgia because it doesn't work like that in California.
No, ma'am. But that's the problem. Everybody comes to Georgia thinking it works like it does up north, where it's no, it does not.
Well noted. Well noted.
You can't just come here thinking you know the law. No, ma'am. It doesn't work the same in any other state. Every state has nuances.
Absolutely. I never said I knew the law. I'm not an attorney.
You did. You said I did it by the law. And you said that 3 times to me. When I first asked you what was going on, you talked about I did it by the law. And then you immediately told me you had a month to month and a lease.
Are you going to be able to set a date where she needs to render the money, or do I need to garnish her?
No, ma'am. You need to do whatever you need to do to collect it. I don't collect. I just give the judgment. So $350 for the judgment.
All right. Plan. Thank you.
You're welcome. Take care, ma'am. All right, Miss Leake, you'll pay the $350.
Okay, ma'am. Thank you so much.
All right. You're welcome.
All right. Bye-bye.
Okay. All right. So the next case, did we ever get Mr. Willie Bell back online?
Yeah. Sorry, Your Honor. He was here, and we keep having trouble with Zoom. I've called him a few times during the break. I'm still working on him. If I could just get another 5 minutes or so, I'll.
All right. We got a 1 o'clock, so we'll be back at 1.
Okay. Thanks.
All right. Thank you.
All right.
All right. Court is down until 1 p.m.
Thank you.